In other stories now, Socio-Economic Rights and Accountability Project has filed a lawsuit against the government of President Bola Tinubu and Nigeria's 36 state governors over the repressive use of the Cybercrimes Act of 2024 to criminalize legitimate expression and violate the human rights of Nigerians, including activists, journalists, bloggers, and social media users. The ECOWAS court had in its judgment dated 25 March 2022 ordered Nigerian authorities to stop using Section 24 of the Cybercrime Act of 2015 to prosecute anyone on the grounds of insulting or talking public officials online. The court declared Section 24 as arbitrary, vague, and repressive and ordered Nigerian authorities to repeal it in conformity with the country's human rights obligations. But while the Cybercrimes Act 2024 has repealed Section 24, it has not cured the arbitrary, vague, and repressive nature of the provisions. SERAP said the Cybercrimes Act of 2024 provisions have opened the door to criminalizing the legitimate expression and punishing activists, journalists, bloggers, and social media users. SERAP also said rather than using the amended legislation to make cyberspace and its users safer, Nigerian authorities are routinely weaponizing it to curb Nigerians' human rights and media freedom. Well, Frank Tietie, lawyer and a rights analyst, joins me now to look at this development. Thank you so much for coming on the news nights. This has raised serious concerns about the state-free expression in the country. Maybe we should start from the act itself. Help us understand the broader implications of the Cybercrimes Act as amended on Nigerians' human rights.
Well, I think first it was quite interesting that the Nigerian government did, obey, I would say, the order of the ECOWAS court to repeal and amend Section 24 of the Cybercrimes Act of 2015 to make it in conformity with the provisions of the African Charter on Human Rights, Human and People's Rights. Now, the question, therefore, is cyberstalking has been made a crime in the Cybercrimes Act to the extent, before its amendment, if anyone sent a message that is pornographic, that is in any way considered to be hateful, that is obscene, that causes anybody to be angry, to be annoyed, or feels insulted, or engenders any form of hate, that person can be arrested, prosecuted, and asked to pay 7 million naira fine or be sent to prison for 3 years. So that's been the provision of Section 24, subsection 1A, and then it also extends to paragraph A and B. Now, with the court ruling, which is a good thing, because with what SERAP is doing, it means that there is hope that through the instrumentality of law, Nigeria can actually step up and conform its standard of law enforcement to internationally acceptable standards that Nigeria itself not only acceded to, but ratified pursuant to the treaties that it signed. However, the challenge is this. SERAP had been to court to declare Section 24, the particular section of 24, Section 24, subsection 1, paragraph A and B, to be, vague and to be oppressive and counterproductive in terms of, restricting freedom of expression. The court has already ruled, and the Nigerian government has complied. Unfortunately, when the Nigerian government made the amendment, by substituting paragraph A and B, by saying, if you post anything that is pornographic, and also post anything that is that to be false, but it has a capacity to cause breakdown of law and order and threatens anybody's life, that person will now be held liable, in terms criminally liable. So SERAP is not saying, look, you appear to have done more harm than good. You haven't done anything. You simply just repeal, substitute it. It's even something which is more nebulous. So it's going back to the court. However, in reality, there's a different ballgame entirely, because the people are asking, you really can't allow the internet. You can't allow people to go crazy on the internet, in the social media, and turn it to a form or weaponize it against their enemies. There must be some laws. There must be some sanity. And I think the Nigerian government, to pursuant to the Constitution, which allows the National Assembly to make laws, which do not necessarily restrict, but restrict this freedom of expression, but to put some sanity. I think that's the balance that is being contested here.
But the question is that, I mean, what the argument SERAP is putting, if you obey the court order in the first place by repealing that Section 24 of the Cybercrime Act of 2015, the other part, which they called vague, repressive, in terms of which is has
it's
to
actually the amended part that which SERAP asked for, that
yes.
the Nigerian government repealed and substituted.
So,
in fact,
so the question is,
yes.
why substituting that? Why do you have to substitute if you're repealing? So there has to be that entirely
but the order of court was,
overhauling and then harmonize
the order of court. The order of court
that
was
section
clear. The order of court
act
was that you repeal it, amend it, and make it in conformity with another parent law, which is the African Charter on Human and People's Rights. It's an international law which Nigeria has domesticated. It's actually a Nigerian law. So what the government has done by removing all such provisions before the amendment, if anyone felt insulted by what you published, the person you could be arrested and prosecuted and possibly go to jail for 3 years. But with the amendment, it only restricts it to issues like of posting pornography or posting anything that you know to be false that is capable of causing breakdown of law and order, or anything that threatens anybody's life. So the Nigerian government has actually has amended it to remove such frivolous and such wide interpreted words like insult, hate, and annoyance. It has removed all of those ones. So, but you see, look, there must be, and I want to respect the sub judice rule, so I won't go into the arguments of both sides, but we cannot stay away from the fact that there must be some regulation for social media. Let us look at the crux of the matter. The crux of the matter on the part of SERAP is that do not criminalize freedom of speech when it goes wrong. When it goes wrong, send the people to a point where they can prove truth, or the person who is complaining can prove the falsity of the statement. But let's not forget, there's nobody who is I would say, the bigger champion of human rights in this country than a personality like Femi Falana. When he suffered an attack on his reputation, in terms of in the social media, he had to exercise extreme restraint not to criminalize what was done to him. To lie against him. So the point is this: with the widespread and exponential nature of the social media, I don't think that we can afford not to criminalize certain acts of persons who use social media wrongly.
Let's look at how to bring a balance into this between regulating cyberspace and protecting Nigerians' rights to freedom of expression or free expression
in this country.
And mostly, just to land on that question, in recent time, what we've seen is that journalists, activists are mostly targeted in this case.
That's a challenge. Here's the point. My viewpoint is that I take myself as an example. I think I have, to a large extent, of freedom of responsible free speech in this country. I do. And as someone who is a media personality and a lawyer in practice, and then who actively uses the social media, I can say, so the point here is that where the social media, where free speech has now been elevated to a point where it's capable of causing irreparable damage to people's reputation to earn money, reputation to live life. That people commit suicide because of false information that has been pervaded about them in the social media that they don't have the capacity to return. Now, when Section 39 of the Constitution guaranteed freedom of expression, the freedom to hold opinions and freedom to express them, it did not contemplate that there would be a social media, because before now, only the president can approve a license for you to own a radio station or a television station or any of such kind of media in this country. But as we speak, There are individuals who in this country, like Joe Rogan in the US, that are capable of changing the whole narrative of an election. They are able to, with one comment, they are able to change the entire, the landscape in terms of whether there is peace, security, or any form of tension. So you don't think that a responsible country, and I do not hold a brief for a country or the government, but you don't think a responsible country will look at, especially a third world country that is struggling with issues of stability, and not say that it will regulate the use of such medium and then place restrictions. I believe, because of the possible damage that can happen as a result of misuse, abuse of social media, there should be some measure of criminal sanctions when people deliberately, knowing that something is false, they publish it and then they ask you to go and find a way to do damage control. No, I think it's a responsible thing for us to realize that certain persons should be punished when they deliberately abuse and misuse the social media.
I agree with you. I think that's to the extreme. But let's look at how the government is going to respond to this. I mean, SERAP is in court at the moment. And they have put a very strong argument with regards to what they describe as vague, repressive, and all of that. So how do you think the government will respond to it? Do you think there will be a review? Do you think SERAP will win in court? Because of course, SERAP as an advocacy group.
Because I will observe the sub judice rule. I will not be able to make that prediction. But there's something very curious in this particular application, which I do not find.
I'm asking you to speak in regards of perhaps there will be a review of that SERAP is putting forward, demanding that the government perhaps withdraw, that particular area.
I believe SERAP is going back to court because it is not satisfied that the Nigerian government complied enough with the provisions. With the provisions of the earlier or a judgment. But in practice, let me be honest with you. Nigeria belongs to us. We own Nigeria. And then we have municipal or national courts that can deal with this matter, from the Court of First Instance through the Court of Appeal to the Supreme Court.
Right.
I would have expected, because the Section 1 of the Constitution provides that if there is any law that is inconsistent with the provisions of the Constitution, that law stands to be void, and to the extent of inconsistency. I would have expected, because that we approached our own courts. Go to the Federal High Court. Even though there is risk in having a single judge sitting that can be actually, that can misdirect himself as to the law, there is an appeal court, and ultimately the Supreme Court, so that we can lay to rest. We would have, if it were a Nigerian court, it would have declared that this particular section is inconsistent, and as such, it will be set aside, and then it will actually, be totally void. But the ECOWAS court may not do that, because because international courts have a way, especially where where the court is constrained actually to protect the interest of member states. It was not only until recently, maybe in 2005, when the supplementary protocol allowed individuals and NGOs to be approaching the ECOWAS court. It was supposed to be meant for only between the states that form ECOWAS. So now the expectation is that there might also be confusion. So the courts may may again give a declaratory judgment which it may not enforce. That is why some of us were actually pleasantly surprised, that the Nigerian government, even though it was smart by half, did in fact obey the court order by repealing and amending. However, Nigerians, because in the ECOWAS court, you find judges from other parts of West Africa making the decisions for Nigeria. But if it were a Nigerian court will understand that, do we really want to restrict the social media? Do we really want to criminalize, mistakes that happen as a result of comments that are harmful in the social media that we term now cyber stalking? Or do we want a free country where you can say anything and do anything against any person's reputation, and all that happens that you go to court, and if you are found liable, you simply pay a certain amount of money? And look at the people who are using social media. Majority of them, and I dare say, are very broke people who just have access to phone. Then would they have money to pay any form of compensation when the damage has been done? You cannot imagine. And I can't cite a better example than what was attempted to be done to Femi Falana by the Bobrisky saga, where a man who has built an impeccable reputation of that nature, and then somebody says he has he asked for money to bribe somebody or to get something done against the law. I mean, it's such an impossible thing that the man would have been able to do, but it was there, published, and somebody was saying it. The tape was being played. You cannot do much damage than that. And then the goal of criminal law is that it should serve as, when you punish people for doing what is wrong, it serves as a deterrence for others who are watching, so that you don't do what do we want to turn our society into. So where we want to turn the social media to a place of name calling and calling out people for the phone of simply because you have access to the phone.
Let's wrap it up with this. I mean, where's the place of accountability? I mean, of course, we understand, I mean, when things like that happen between, maybe a prominent Nigerian and, of course, another Nigerian. But when we talk about holding the government accountable, where should we draw the line?
See, let me be honest.
Without, gagging the rights of Nigerians to freedom of expression as rapidly.
I find this very difficult, and I know for certain that many people will disagree with me. But in my practice as a Nigerian lawyer and a quasi-journalist by virtue of my media work, I do not see any restriction in publishing what I consider to be true. I do not see, and I'm not afraid to do that. Because there are laws. If I pick a report from the National Bureau of Statistics today, I will be able to indict anybody that I want to indict, because we are talking about objective information.
Right.
Truth is objective. So I think the pursuit is about truth and not this deliberate attempt at misinformation, disinformation, and then purveyance of fake news. So I think as a responsible third world country, because we are, by our institutions and by our mentality, by our level of education in this country, we're a third world country, we're a developing country. I think we should be very careful in the way we manage some of these things, rather than turn this whole place. You want to compare us to the kind of freedom that exists in the US, where you post also. Even at that, you find defamatory laws in place and people answer to it. You see, defamatory laws were actually established to protect persons against violations that can come from big newspapers and media houses. But in this case, we're not talking about ordinary individuals who can do 10 times more damage than what a media house would have done. I think there should be some form of responsible practice. I hope that the Nigerian government would take another look at Section 24, make it more humanizing. But to say that we should outrightly decriminalize, say violations of people's rights in terms of their reputation, in terms of, I don't think so.
Well, I hope that the ongoing advocacy, from organizations like SERAP, maybe it will yield a meaningful reforms.
No, it's doing well, because it's causing conversation, and we're hoping that the country, the government will conform to the right standards. However, citizens must also be responsible.
Lawyer and Arise analyst Frank Tietie, thank you for coming on News Now.